Okay, guys, boys and girls, welcome back. I'm going to do a video today on the New York case, some more thoughts about it. And this is largely going to be about the standard of review. So, if you remember, I did a video a couple weeks ago, and that video talked about did the Chief Justice give us a tip as to what he thought the standard of review, because everybody's been focusing on the carry aspect of this case. And I did an interview with Channel 7 the other day, the day that the decision came out. And with that, they didn't understand that when I said that the carry portion of this was the secondary, that was the icing on the cake. The takeaway from this decision was we got a standard of review, and a standard of review that impacts pretty much all the litigation prior that's been decided against us, and a bunch of other laws that we haven't had a chance to go after just yet. So with that, there's a lot of stuff here. So I'm not going to do a dual screen capture on this one. I've had some issues with that. So I'm going to read from my screen, then I'll drop the graphics in a little later. If you go to what I said before, the Chief Judge hinted that shouldn't we just go back to Heller? Shouldn't Heller be the standard of review? Because there's this long-running debate about whether or not 1791 was the applicable time to look at. Was it 1868 with the 14th Amendment? What was it? And pretty much they've gone with a mixture of Heller being the predominantly source of what to look at, with some text and history. Now, for years, if anybody has listened to any of my rants in front of the judicial, the legislative committees and other places, I have consistently talked about page 63 of the Heller decision, and I was right. The court cites that standard numerous times in here. So let's get to the decision and let's talk about this. In the very beginning, the opening paragraph. In this case, petitioners and respondents agree that ordinary law-abiding citizens have a similar right to carry handguns publicly for their self-defense. We, too, agree, and now hold, consistent with Heller and McDonald, that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. I'm not particularly thrilled that they limited it to handguns, but they did, and that's in keeping with the Heller decision, where they said it's not to carry any firearm any way you want, anywhere you want, kind of thing. But that was significant. So we scroll down here a little bit to page 14. Page 8. In Heller and McDonald, we held that the Second and 14th Amendments protect an individual right to keep and bear arms for self-defense. Important here, keep and bear, and the note the use of the word arms. So they didn't say firearms. They didn't say guns. They said arms. So that all is going to fall into what we get to argue about going forward. And previously, the Seventh Circuit Court of Appeals in Ezell came up with a two-step approach. And they would look to see if the conduct fell outside the Second Amendment and all this stuff. But let's read what the court said. Today, we decline to adopt that two-part approach in keeping with Heller. Again, Heller is the standard of review. So they go on. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Huge. That is absolutely huge that they are placing, the Second Amendment's unqualified command at the forefront. Heller is the standard of review. The Chief Judge was right. We called it. And the other part of this, as we scroll down here, let's talk about this two-part approach. Despite the popularity of this two-step approach, it is one step too many. Step one of the predominant framework is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history, but Heller and McDonald do not support applying means and scrutiny in the Second Amendment context. Instead, the government must affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. So, a couple of things here. Again, Heller is the standard of review, not intermediate scrutiny, not interest balancing, not means end. It goes right back to that paragraph in page 63 that I've been harping about for the last 10 years that our side, quite frankly, has not put into the briefs. They have not argued that point. They have not talked about that point. Rarely, if ever, do they go back and say, page 63, it's not an interest balancing approach. And the court noted that. It noted the interest balancing. So let's go, Heller is the standard. I'm going to harp on that. Heller is the standard. To show why Heller does not support applying means and scrutiny, we first summarize Heller's methodological approach to the Second Amendment. And they spend some time going through that, but as they recant their Heller decision, as the foregoing shows, Heller's methodology centered on constitutional text and history, whether it came to defining the character of the right, individual or militia dependent, it was individual, suggesting the outer limits of the right, or assessing the constitutionality of a particular regulation, Heller relied on text and history. It did not invoke any means and test such as strict or intermediate scrutiny. We lost a bunch of decisions on intermediate scrutiny, and they talk about that. Back to the decision. Moreover, Heller and McDonald expressly rejected the application of any judge-empowering interest-balancing inquiry that asks whether the statute burdens a protected interest in a way or to an extent that is out of proportion to the statute's salutary effects on other important governmental interests. There is no interest balancing. That was the heart of page 63 in that portion that Scalia put up there. That was the absolute heart of it. And, the courts have just glossed over that. Continuing on page 14, we decline to engage in means and scrutiny because, and this is a direct quote from that part, the very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. Heller. We then concluded a constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all. The judges are not to put their own interests, their own beliefs. Judge Easterbrook and Posner from the Seventh Circuit Court of Appeals have been firmly rebuked when Easterbrook used feelings in the Friedman case in Highland Park. They have now been firmly rebuked. And this part of page 14 goes on. Not only did Heller decline to engage in means-end scrutiny generally, but it also specifically ruled out the intermediate scrutiny test that respondents in the United States now urge us to adopt. Intermediate scrutiny is gone. Any decision, Friedman, Culp, Wilson, any of those that relied on intermediate scrutiny, dead letter law. Those cases have no value in precedence to be cited by lower courts as appellate court decisions. Nope, not happening. It is over. It goes back once again to page 63. I think I'm gonna get cards with that thing printed up. It's too long to put on my arm as a tattoo. My arm's not that big. Thus, when Heller expressly rejected that dissent's interest balancing inquiry, it necessarily rejected intermediate scrutiny. Gone. In sum, the Courts of Appeals' second step is inconsistent with Heller's historical approach and its rejection of means-end scrutiny. We reiterate that the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. There is your standard of review. That's it. The government bears the burden of proving that the conduct falls outside the Second Amendment, or that there is a strong history that shows that the conduct has been regulated in a particular way. This is huge. I can't go on about just how big this is. That is the standard. This two-part approach that the Seventh Circuit adopted, they have thrown out. Our state Supreme Court has adopted it. Well, not anymore. I'm sure that the other side is going to try to drive a semi-tractor through the whole of text and history, and they tried to do that in New York, and it was rebuked. They kept going back to some stuff in the 1590s in England. They've tried the Northampton stuff, not having any part of it. It's not working. And I think this is where Thomas gets to go on about the second class right, the redheaded stepchild that he has called Second Amendment litigation. And if the last decade of Second Amendment litigation has taught this court anything, it is that federal courts tasked with making such difficult empirical judgments regarding firearm regulations under the banner of intermediate scrutiny often defer to the determinations of legislatures. But while that judicial deference to legislative interest balancing is understandable and elsewhere appropriate, it is not deference that the Constitution demands here. The Second Amendment is the very product of an interest balancing by the people, and it surely elevates above all other interests the right of law-abiding, responsible citizens to use arms for self-defense. It is this balance, struck by the traditions of the American people, that demand our unqualified deference. Unqualified deference. We defer to the Constitution to, shall not be infringed, now actually starts to mean something with this. The test we set forth in Heller and applied today requires courts to assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. Now they go through some dicta here about what the courts are going to have to consider and look at. I'm not going to get way deep into the weeds on that. And again, places like Chicago, Cook County, and liberal judges are going to try to drive a bus through that. But I think that Thomas has been paying attention to what the lower courts have been doing, and I think he clearly came in here to throw some handcuffs on them and tell them they've gotten it wrong, they've been getting it wrong, you guys didn't listen to what we had to say, and because of that, here you go. We're spelling this out for you as clearly as we can. And again, I think this is going to be huge. It goes on page 19. Its reference to arms does not apply only to those arms in existence in the 18th century. Just as the First Amendment protects modern forms of communication and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Thus, and that is a quote from page 8 of Heller. Again, Heller is the standard. It goes to page 8. We talked about that in my other video. That if we are left with Heller being the standard and modern arms are protected and it's not subject to his interest balancing approach, which I think gets to mag bans and other things, the antis aren't left with a lot. All right, so under this decision, they can have a reasonable licensing regime for the carrying of a gun in public. They didn't say that you can have a license for ownership possession like the FOID card. They only endorsed a licensing scheme for carrying a handgun in public. And this part goes on. Thus, even though the Second Amendment's definition of arms is fixed according to its historical understanding, that general definition covers modern instruments that facilitate armed self-defense. ARs, AKs. That's, I think the semi-auto bans are dead. I think by the first of the year, we should have at least a couple of rulings on that. We know the Ninth Circuit has some stuff pending up on it. I'm not sure where all those cases are. I'll make a note. I'm going to go back and call my buddies out in California, Chuck Michelle and company, and I'll get an update on where all the cases stand, what parts they're at. It would not surprise me that with the ruling we got Thursday, that several of the cases pending cert at the Supreme Court, that they kick back on a vacated, remanded, and try again. I think they call it GVR, and I think that's it. Back to part of the standard review, we get down to, therefore, whether modern and historical regulations impose a comparable burden on the right of armed self-defense, and whether that burden is comparably justified are central considerations when engaging in an analogical inquiry. So when they look at it, everything is focused, the largest portion of it is focused around armed self-defense and whether or not the burden. Now, if you go back to Heller, remember that they said we outlawed handguns. The district said we outlawed handguns, but because they have rifles and shotguns that are available to them. And Scalia shot that down, said that's not an answer. That is not an answer. So that argument has already been dealt with in Heller. Heller is the standard. So when Cook County, Chicago, or somebody else says, well, we took away 15-round magazines, but you're left with 10-round magazines. Nope, no good. Or we're taking away AR-15s, but you're left with, all these other, nope. And good old Uncle Joe, let's go Brandon, about your shotgun, not happening, brother. It is over. So, let's see. And they go on to talk about the analogies that judges can make or look at to kind of clarify the standard here. To be clear, analogical reasoning under the Second Amendment is neither a regulatory straitjacket nor a regulatory blank check. On one hand, courts should not uphold every modern law that remotely resembles a historical analog, because doing so risks endorsing outliers that our ancestors would have never accepted. That's Drummond v. Robinson. On the other hand, analogical reasoning requires only that the government identify a well-established and representative historical analog, not a historical twin. So even if a modern-day regulation is not a dead ringer for historical precursors, it still may be analogous enough to pass constitutional muster. This is the hole that they are going to try to drive the bus through. That's it. They're going to say, well, it's close enough. And we're going to hold their feet to the fire and say, no, it's not. And I think, they've given us enough in here about modern guns and things like that. Yeah. So going on to page 23, having made the constitutional standard endorsed in Heller more explicit, we now apply the standard to New York's proper cause requirement. So 23 pages of this decision are dealt with the standard of review. The first 23 pages are nothing but the standard of review, once again citing that we made the standard in Heller and basically said all you lower courts were too stupid to read what we wrote. You're just too flippin' stupid to actually pay attention to what we wrote towards the end of the decision. And that's just amazing. That is just absolutely amazing. But let's go back. So what did the court say? What is that entire passage that I've always talked about on page 63? We know of no other enumerated constitutional right whose core protection has been subjected to a freestanding interest-balancing approach. The very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. A constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them, whether or not future legislatures or, yes, even future judges think that scope too broad. We would not apply an interest-balancing approach to the prohibition of peaceful neo-Nazi march through Skokie. The First Amendment contains the freedom of speech guarantee that people ratified, which included exceptions for obscenity, libel, and disclosure of state secrets, but not for the expression of extremely unpopular and wrong-headed views. The Second Amendment is no different. Like the first, it is a very product of an interest-balancing approach by the people, which Justice Breyer would now conduct for them anew. And whatever else leads to future elevation, it surely elevates above all other interests the right of law-abiding, responsible citizens to use arms in defense of hearth and home. That was page 63 of the Heller decision. That is the standard. Elevates above all other interests. No interest balancing. And the funny thing is, Breyer has gotten it wrong twice in a row. He was called out in this one. He was called out in New York, and Justice Alito specifically took him to the woodshed for a severe tanning in his concurring opinion. So that's it. The chief judge tipped us off. We caught it. We talked about it. We pontificated. Is this what we're about to see? And so with text and history of our country and the Constitution and the Heller decision, that's it. So I'll do another video with a walkthrough on Heller and pointing out the relevant sections I think are going to make a play for us. But we're in a really good spot. All right, guys, signing off. If you like it, hit the subscribe button. We'll have more of these coming around. Thanks.